Hi, welcome to another episode of the Financial Freedom Podcast. I'm Steve Richardson, a bankruptcy attorney trying to keep people on their path to financial stability and independence through education. One of the things that many couples and individuals think about, know they need, and fully intend to get one day is an estate plan. But what is it? Is it just a will? What can happen if you put it off for too long? So that's why in this episode of the podcast, I talked with estate planning attorney Adam Zuckerman to get a good idea of what an estate plan is, why you need one, and why you shouldn't wait to get one. My guest today is Adam Zuckerman, the founder of Buried in Work, a leading e commerce platform specializing in estate planning and organization, end of life tasks, and estate transitions. With a deeply personal motivation stemming from his experience managing his father's estate, Adam is dedicated to simplifying these complex processes for individuals and families nationwide. As an Eisenhower Fellow, attorney, and MBA, Adam brings a wealth of expertise to his role, combining legal knowledge with entrepreneurial vision to drive innovation in the field of estate planning. Welcome to the show, Adam.
Steve, it's great to be here. Thanks for having me.
Well, I see where you were somewhat inspired in managing your father's estate. A few years ago, my father-in-law passed away, and he had a revocable living trust and a will and things like that. So I learned a lot about those, helping my wife administer it. So certainly, somewhat the same experience in getting into this field, and I think it kind of stresses once you do it that how important having an estate plan is.
hmm
So just talking about estate planning, people hear that, and I think to some extent they think, oh, that's for rich people. I don't need an estate plan. I just need a will, right? But uh, so to kind of answer that question, what exactly is an estate plan? How is it different from just a will?
hmm
And why do people need them?
That's a great question. So, high level, estate planning is the process of anticipating and arranging for the management and disposal of a person's estate during their life in preparation of when they're incapacitated or pass away.
Uh
That's a
huh.
really typical definition. If you want to boil it down to its core tenets, an estate plan is saying, I'm organized in the event something happens to me. And a will is, in fact, a component of an estate plan. We believe in comprehensive estate planning, which goes far beyond just having a will or a trust. It's a mechanism where if something were to happen to you, you want your family to be able to step in seamlessly, effortlessly, and pick up all of the pieces that you'd imagine in your life would fall apart or continue on without you being involved. Um, What's really interesting about that is that every single person in the United States has an estate plan, whether or not they like it or not, or even know it or not. Everybody has an estate, even if you have very little assets to your name, you have an estate. It's what you own, it's the clothes on your back. And if you don't have a will, the state will have a process that your estate will go through intestate. And that means that you have a choice. You can take control of your own estate, of your own destiny, or you can sit back and the state will take care of it for you.
So the estate plan also not only the settling of your affairs at the time of death, but it also
Mhm.
involves some other documents, doesn't it? That are useful while you're alive, that are a part of your
Absolutely.
estate plan. And I think that's why people don't think of it that
Yeah,
way. They think of an estate as when you die, and that's a will. So, what are some of the other documents you see in an estate plan?
that's a great question. So, foundationally, most people say that the will and a trust, and there are many different types of trusts, are the core foundational elements of an estate plan. But it goes far beyond that. You can have advanced directives, and advanced directives are an umbrella term that, depending on where you are, they mean different things. Sometimes it's a set of specific documents that a state says this is what an advanced directive is, or other times it's a collection of documents like a living will, which is non binding, it's a healthcare proxy, it's a healthcare agent. It's a DNR, do not resuscitate directive. It's power of attorneys, and those can be financial, those can be medical. What those mean is that somebody's able to act on your behalf in the event that you can't speak for yourself. a POLST, POLST, which is a portable medical order that's binding as well, and a whole host of other documents as well. You can go down the rabbit hole to find legacy messaging documents, you name it. And the reality is that you're unique, just like everybody else is, and your estate plan needs to reflect and take into account your specific wishes and where you are in your life, not only for today, but for tomorrow into the future, because an estate plan, just like you, has to evolve over time.
Right. And basically a will is just an
Mhm.
an instruction sheet on how to transfer the assets of the estate to your heirs. Who gets what? And if you don't make that decision, if you don't lay out those instructions in a will, the state will do it for you. You mentioned intestate succession,
Yeah.
and that may not be what you want. You think, oh well, it's everything to my spouse, and if my spouse predeceases me, my children. Well, what if this is a second marriage? What if you have children by a previous marriage? It gets
Yeah.
kind of complicated. And that kind of we'll get into what happens if you don't have a will in a minute. But there are some other planning things and instructions you may already have. For example, at least in New Jersey, uh, a married couple owns their home and both names are on the deed. Well, one of them dies, the other one automatically gets title, takes over title, and is now the sole owner. You don't need that to be in the will. You don't need that to be in the instruction set or anything else. Same thing with things like a joint bank account, things like a car, certain assets that can be titled as a matter of record to both spouses. So it
That's
doesn't
right.
even go through probate. And so it's simple. You already have that plan, right? And if there are creditors of the estate, since it's not in the estate, it's not reachable by creditors, right?
Yeah. There's a lot of really neat nuances that, unless you've gone through it before, unless you've studied it for some particular reason, you probably just won't be aware of it. I was
Mhm.
speaking to a gentleman in Virginia a little while ago, and he was married. He had two children, and he now has an ex-wife. Got divorced, and he said, Adam, I updated my will. If something were to happen to me, the old analogy of if I get hit by a bus, you know,
Right.
50% goes to one kid, 50% goes to another kid. My estate plan is set. I'm fairly simple. And I asked him about his payable on death beneficiaries, which is what you just mentioned in a roundabout way.
Mhm.
Whereas if something were to happen, you have a designation on your bank account or your insurance policy of this is what happens to these assets. And he never updated them from his now ex-wife. So guess what? Payable on death beneficiary designations are contractual. Those get processed before your will. So unless he updates those, if something were to happen to him, his ex-wife receives all of his assets from those accounts and policies. You might not notice that. So there's a lot of little nuances that are very jurisdictional specific oftentimes, like you just gave the example in New Jersey. And it's really important that if you want to do it yourself, and you can completely do that, you need to go and research the local jurisdictions of where you are. And if it's a little bit more complicated, it's probably a good idea to involve a seasoned professional as well.
Exactly. And those little things you don't think about. Again, I just need a will. Well, no, wait a minute. Has there been a life change? Have have you gotten divorced? Have you gotten married? Uh,
Mhm.
and you need to look at, well, who's the beneficiary on the life insurance policies?
Mhm.
Who's the beneficiary on the IRA or the 401k or all these
Mhm.
other little accounts that you have? We talked about a joint bank account that's held by husband and wife or by spouses, right, by the entirety. That can pass, but again, um, if you don't change that, then you're right. The ex-wife could get the life insurance policies. The ex-wife could get the money in your IRA,
Yeah.
and even that joint bank account. You may, hey, I'm great. I've my spouse gets if I die. If you get divorced, it then becomes tenancy in common, and then you die, well, your half goes into your estate, but the other half goes to your ex spouse.
Yeah, it can be very complicated. And I think that the key that people need to understand is two things. First, you have to be organized. You have to get your information together because without having it organized, you're not going to be able to create that plan. And the analogy that I like to bring is cooking a cake, baking a cake. So, Steve, if I invite you over to my house to bake a cake and you come in the door and I have no recipe, I have no ingredients, and all I know is that we want to bake a cake, it's going to be pretty complicated to bake that cake, right? But if I had the ingredients, it's a lot faster. And then if you draw that analogy forward even more, if I'm asking you to bake the cake using only ingredients that I know about, but I can't talk to you about those ingredients at all because I've passed away, it's going to be very difficult on you. And that's the situation that a lot of people in the country are about to find themselves in, and oftentimes do find themselves in. Whereas administrating an average estate takes 570 hours of time. And I don't know about you, but finding 570 hours of time is pretty difficult for a lot of people. So if
Mhm.
you take the time to organize your information now, whether you have a will or not, organize what you have, get your account statements, make sure the payable and death beneficiaries are correct. And this goes far beyond just having a will. It's your citizenship information, your identification, your career, education history, where you've lived, your online digital legacy, such as email accounts and passwords. You need to get all of that together. And then after you have that, then you can revisit your will, whether you need a trust, whether you need other complicated, advanced estate planning mechanisms to really put your family and your wishes into a place where your loved ones can really carry them out.
Exactly. And we've kind of talked about, the things that can go wrong um, if you don't have an estate plan.
Mhm.
Are there any other things you want to point out to folks, the listeners, other than what we discussed, that could happen if you don't have a good estate plan?
Yeah, so effectively think of it this way. When somebody passes away, it is likely one of the most stressful periods of time in your loved ones' lives.
Hmm.
That's your family, that's your friends. It can even disrupt business, your coworkers, clubs that you may be a member of. So the ethical thing, and I say ethical in quotes, thing to do is to leave it as organized as possible because that minimizes that stress on them. It minimizes potential for conflict. What a lot of people think is that, oh, I've given my son, I've given my daughter the keys to my safe. They'll be totally fine. But the reality is that the time for people to figure out what you want to have happen is not after you're gone. In an
Right.
estate plan, a lot of people jump from this is what I have today to this is what I think is going to happen after I die. And if you just look at those two ends of the spectrum, you're missing a massive part of your life, which is all of the steps leading up to that end of life.
Hmm.
So, what Buried in Work does is we separate things into three different buckets. One is organizing and estate preparation. So, this is what I have. Let's figure it out. Let's do it myself. Let's connect with a service provider if needed. And there's checklists and guides and quizzes, you name it. There's even card games now to help you preserve memories and figure out where you are in your status in life as it relates back.
Hmm.
The second bucket is end of life tasks. So what do you have to do right before someone passes away and right after, leading into the funeral itself or their end of life plan itself, because that too is part of an estate plan. So a lot of people say, oh, I've got that little yes check on my driver's license. I'm an organ donor. But what they don't realize is what that means is that you're an organ donor only if you die in a hospital because you have to be on life support effectively for your organs to be harvested. And your wishes of potentially donating your body to medicine or science, that's not going to come to be, even though you may want that without having a contract in place with an organization long in advance.
Hmm.
So you really have to take a full spectrum approach. And then the third thing is after you pass away, when you no longer have active living say in what happens. People have to carry out your wishes. What happens with estate transition and probate? And that's where things can get really complicated with your family. That's when, a lot of people have that image of a lawyer walking to the room with a leather portfolio and everybody sits down for the reading of the will, like they show in the movies. That generally doesn't happen that way.
Hmm.
Uh, but it's up to you. If that's what you want to have happen, talk to your attorney. They can make that happen as well. You're unique, just like everybody else. Again,
Exactly. But like I said, you make more work for your heirs if you don't have an estate plan. Uh,
absolutely.
as far as your probate estate, in other words, the distribution of your assets um, upon your death, if you don't lay that out, then the state intestate succession laws come in, and people may that basically just liquidates the entire estate, and distributes according to a roadmap that the statute lays out. But what if you
Mhm.
have certain family heirlooms that you want a particular
Yeah.
person to have, or you want a specific bequest or charitable donation or things like that? All of that's going to get lost.
It's that, and also, what if you have minor children or dependents? What
Yes.
happens to them? What if you have pets? We have a product called the Estate Preparation Package, and it's been described as the most comprehensive estate organization system you can have. We literally worked with veterinarians to develop the pet profiles, with CFPs to develop the asset profiles, liabilities. There are so many things that you just don't realize need to be taken account into your daily life because you are so routine at managing them yourselves. But think of it this way. If you put everything on pause, you no longer could answer your emails, you no longer could answer your phone, right? You had to stand in a box or go to an island for 3 months, just mysteriously. What would happen to everything in your life? That
Mhm.
chaos is what you're about to set your family up for if something were to happen to you tomorrow and you don't have that estate plan in place.
Exactly. And they're trying to figure out your wishes, what you might want. And that's
Yeah.
not just your um, distribution of assets. It might be you may want you may have specific preferences for the your remains. You may want to be cremated. You may want to be buried. You may want to have your ashes scattered somewhere.
Yeah.
You may have some particular wishes, and you want to make sure those are made known, right?
That's absolutely right. And then within that planning process, if you have $250,000 to $500,000 up to $1 million, maybe you can do some basic will, crafting yourself. Make sure that you follow the local jurisdiction requirements because some states have different requirements. You may need to have two witnesses. Those witnesses might have to be an adult and of sound mind. They may not be able to be related to you. You may have to sign in one of their presence at least. It may have to be in both of their presence. It's a lot of things that you have to take into account to make that will legal and binding. The last thing you want to do is write something down, think it's legally binding, and the court goes, "Nope, you're actually back in our process. You don't have a say."
Mhm.
And then you can get to the many different types of trust that look out for you, like a revocable living trust, where it protects your assets from probate. You get to avoid probate. It maintains your privacy because trust documents aren't filed with the state. And you get continued control where you can change that at any time you want. And then it
Mhm.
goes on and on and on and on from the different various mechanisms and levers that you can pull as your asset classes increase.
Right.
But the reality is you have to start now because the last thing you want to do is if you're on your deathbed or someone's sick when you can be spending time with your family and your loved ones, this is not the topic that you want to be talking about. And trust me from experience on that.
And not only and there's a problem that are created for your loved ones beyond just not having a will, not having some of these other documents. If you don't have an advanced medical directive or a living will,
Mhm.
uh, where you're still alive, or you don't have a financial power of attorney, that can create some other problems while you're still alive, right, for your family.
That's right. Yeah. And in that, you need to educate your family as well. So, what we tell people is if you start your estate plan, the second thing that you need to do after you start down that road is tell three trusted people that that estate plan exists and where to find it. Because if you
Right.
do a lot of work and it's locked away in a safe somewhere, that does nobody any good if they never find that document. So, first thing, start. Second thing, tell people that you've started and where to find the documents and who to contact. The second thing is, or the third thing then is to educate people. You don't have to tell them specifically what's in those documents, but you should educate some people and ask permission. So if you're designating a guardian for your children, if they're minors or dependents, you might want to ask them if they're up for the task because they can decline even after you pass away. If you're granting somebody a power of attorney, which is revocable, so if we talk about medical power of attorney, it's somebody who can act on your behalf, or financial, act on your behalf on your accounts. They need to know that that power immediately terminates the minute that you pass away as well. Countless times we've had conversations. I don't understand why this bank won't talk to me. I have power of attorney. No, you don't. Your power of attorney has terminated. It's done. It goes to the administrator of the estate or the executor or whoever is designated in that process. So it's
Mhm.
really important. Just get ahead of the problems if you can. Do a little bit of research. It's not always the most fun topic, but sometimes it's better to take a little bit of work and effort before you need it for the dividends on the back end.
Well, you raise a good point about you have all these documents. You make sure that the your executor, guardian for your children, minor children, whoever it is that needs to take action upon your incapacity or death, knows where the documents are. It's not uncommon, for example, in where I am in southern New Jersey, in Gloucester County, for the executive director of the county bar to send out an email to the member saying, did any of you do a will for so and so? The family knows there's a will, but they're not sure, what attorney handled it, or do you have a copy, or anything else, because they know there's a will, but they simply can't find it, and it
Mhm.
does them no good if they don't know where it is.
Absolutely correct. And then if you make changes in the will, if you have a codicil, you have to
Hmm.
notate that somewhere so there's no confusion, because we've all heard stories of, oh, the will was getting probated or the will was being reviewed and then somebody found a will on a napkin. Well, which is superseding, which is controlling, which is binding. If you make
Right,
any changes, make sure that it's very clear, this is what I want to have happen, and it changes everything that came before.
right. That's why, I mean, you can have a codicil to change something in the will, but I've always been very leery of that, because what happens if the codicil gets separated from the will itself? So
Exactly
they have
right.
the will, but they don't have record of the change.
Exactly.
So, I just usually just redo the will. Now, I have a question for you on powers of attorney, these
Mhm.
financial powers of attorney. Uh, there are a couple of ways you can trigger them. They can come into effect immediately
Mhm.
or upon your disability, where they can
Mhm.
step in, take care of things while you're disabled. Then, when the disability ends, if it does, then it stops. Which do you recommend? Do you think it should be take effect immediately or upon disability?
I think it's a great question. It really goes to the individual, unique circumstances of the people that are granting and the people that are receiving the power. And the reason why is if you give somebody complete financial authority over you, they can drain your bank accounts whether you like it or not.
Right.
You can then file suit if you want and take legal action to try and reverse it, but it's always easier to stop something from happening before it actually happens. Now, if you trust the person, if it's, your sister, your son, your daughter, your husband, I think that's a situation that is more likely to warrant consideration of immediate powers being granted. But by and large, I think that you have to be very diligent and you need to consult with somebody who understands your situation, your estate, that can really guide you on what those eventualities are.
Hmm.
Uh, the last thing that you want to do is to find yourself in a situation where you are suddenly giving away powers and not in control of your own destiny when you should be.
Well, it's definitely a matter of trust in
Absolutely.
who you give that power to. I what I do is I call it the Rob you blind speech. I
Yeah.
tell them this is a trust issue. Now you can
Mhm.
have effect immediately and put it with your will in a locked drawer. And then if it's needed, that person knows where it is and get to it if needed. The flip side of that is if you have it as taking effect upon disability,
Mhm.
again, it's the same trust issue. But the problem I had with my father-in-law is getting two doctors to put in writing
Mhm.
that he was disabled in order to activate the power of attorney.
Yeah.
So
That's
I think that maybe if you're going to do that, uh, as opposed to just having it have effective immediately, oh, he's disabled, let's unlock this drawer and take the document out. Make sure you have a good relationship with those doctors to make sure that they're willing to sign that letter.
Absolutely. And revisit it often. Anytime you have a springing power. So if this, then that type of power, you
Mhm.
need to revisit that on a regular basis as well. And I'm not saying on a weekly basis or a monthly basis, but a year from now, 2 years from now, 3 years from now, you should go back and just verify this is what I want to still have happen, because the relationship with that individual can change, that trust level with that individual can change, or your circumstances may completely change. You may get married, for example, and you want the person who had that power, that was your best friend or your son, your daughter, whoever that individual might be, to no longer be that person.
Mhm.
So just protect yourself. It is not a moment in time and you're done. This is something you have to go back to over and over and over and update it. And when you do that, and some people just put on a schedule. When I do my taxes, I revisit this, and this. And it makes
Mhm.
it pretty easy because you have that annual occurrence that reminds you. So from now on, it shall be known as April 16th is, family law and estate planning day.
Okay, so let's go back to baking that cake. Uh,
Yeah.
if you're going to bake the cake, you got to make sure you have all the ingredients. When we plan meals for the week, just okay, do we have all the ingredients? If not, put it on the shopping list and go to the supermarket so you're fully prepared. So, what are the ingredients on this cake recipe that we need that someone needs to gather together and decide on
Okay.
before they go to an estate planning attorney or estate planning professional to talk about putting a plan together?
That's a great question. So, on average in the United States, I'm going to put some things in perspective with some statistics, if that's okay. I'm a stats guy
Sure.
sometimes. Every single day, 10,000 Americans turn 65. That means that by the end of the decade, 2030, there will be twice as many people 65 and older as there are today. And there will finally be more people 65 and older than under, which is a complete demographic shift, which means that we are literally living through the beginning of the greatest wealth transfer in the history of humanity. Some
Mhm.
stats say it's upwards of $84 trillion are going to shift over the next 20 years. You likely have a relatively small percentage of that $84 trillion. But
Mhm.
while it is a small percentage in the overall pie that we're looking at, it can be very important to you. So you want to make sure that you're protecting those assets. So the first thing you need to do is really gather all of your information together, because when you go to that attorney, if you're not doing it, do it yourself, they're going to charge you one of two ways. They're going to, or likely charge you one of two ways. Always remember to never speak in absolutes. The first is on an hourly basis, so $150 to $400 an hour, or maybe it's a set fee of a basic estate preparation package for them is, $1,500 to $5,000 depending on what you get. Everything changes depending on who you're talking to.
Mhm.
You can save yourself time, hassle, energy, and make your attorney's job easier and more effective by giving them the information that they're going to need before you start that conversation. And that's effectively what the estate preparation package is. It's multiple notebooks that help you gather everything that they would need. For us, we talk about your family member information, your information, including your pets. Very important. So literally down to what happens to my pets, who are my family members, what is the maiden name of my wife and my parents. Because when something happens, that not only helps your family execute and administer the estate, but it also helps the attorney get everything together. Your citizenship and your identification, because that helps with jurisdictional issues. Your career and education history, that helps not only with obituary writing, but also helps you identify where you may have potential benefits. Those unintended consequences we spoke of earlier. Last week, I heard a story of someone who didn't update a benefits plan from a previous employer, and their ex-wife was going to be the beneficiary of those policies. So you have to go back, and by identifying all these companies and policies, you can really make sure that everything's been updated as needed. Your residential history, that can help with unclaimed property searches. Your digital legacy and digital presence, so that's email, online accounts, and passwords. And Steve, I imagine you've gone through this process before, where 20 years ago, if somebody asked you what account somebody had, you'd probably just say, check the mail, and you'll get the statements in the mail, right? But now it's so much more complicated than that, because you have to check email, you have to check mail, everything else. So your online presence. We're talking about financial assets, your liabilities, if you're involved in businesses, if you have insurance policies, then a copy of your tax returns. A lot of people don't realize that after you pass away, you still have to file a tax return. You won't do it, somebody will do it on your behalf. And then it goes to that mid tier task right before and after someone passes away, and that can be an extended period of time. So you need health information as well. Care information, residence information of, are they in an assisted living facility, something like that. But once you have that core amount of information, which you should be able to put together in 15 minutes, and I say that very tongue in cheek, then if you go to your attorney or you start actually drafting your stuff, you are going to be in a much, much, much better position, because what can end up happening then is you bake the whole cake and you realize they didn't add any salt or any sugar to it. The cake tastes weird and you got to start all over, or at least you got to make a few tweaks.
Mhm.
So
So you
that's a
certainly
long
have to
answer to
get
your first question.
right. You certainly have to gather together everything that you own as far as
Yep.
assets, accounts, things like that. But also you need to figure out who your personnel is going to be. Who's
Yeah.
your executive going to be? Who's the backup? Who's the
Mhm.
going to be the guardian of your minor children, and who's the backup? Who's going to
Absolutely.
be your medical representative, your financial representative, have an alternate for each of those. So you need to come up with a list of trusted people.
Yeah. We
And
we have we have it separated into three binders. So
Mhm.
we say you keep one binder at home. We call that the estate information binder. That's your financial information that you don't want anybody to know about you, your family information. We
Right.
have one binder that is called the health and legacy binder, and that has exactly what you just said, the list of all your key contacts to notify, your end of life plan. This is what I want to have happen at my funeral. Have I prepaid for any of the funeral expenses? It has your summaries of, do I have a will? Do I have a trust? It has legacy messaging, ethical wills. It has a section we call before you forget, or before I forget, like for all the little last minute things that you haven't thought about. And the
Mhm.
third one is a singular notebook that helps people store all the most important documents in one place.
Mhm.
All of that stuff is extremely important, and it solves that problem of everything you've mentioned of you have to have the right information, you have to have it accessible, and you need to update it, because if you don't update it, you're in a bad spot.
Mhm. And just circling back to the
Yeah.
documents in your estate plan, one thing that a lot of people don't think about, and I didn't really think about until I started practicing in this space, is that you may have a will that names a guardian for your minor children if you die.
Yeah.
But what if you and your spouse are in an automobile accident? You're not
Mhm.
dead, but you can't care for the children.
That's right.
Does social services come in and do it?
Mhm.
You know, you need to have uh, a guardianship for those children, or power of attorney, limited power of attorney, guardianship for those kids, so that Aunt Mabel can has the authority to take the children, house them, feed
Yeah.
them, take care of them, get them to school, whatever, while you're in the hospital or while you're recovering and unable to take care of them, and that has to be available uh, to people. I know an estate planning attorney in my area. She prepares a card for the
Mhm.
wallet,
Yep.
and so the EMTs or whatever, they're going through the wall for ID,
Oh,
medical, whatever it is, and they see this card and says, "Hey, if I'm in an accident,
call
so
this
and so
person.
takes care of the kids." Something, or this
That's
is where the documents are for the guardianship.
that's
So just like
exactly.
people need to know where it is, it may not be it may not be Aunt Mabel. It may
Yep.
be the EMT or the police officer at the scene of the accident or something that there's a child in the car who, may be okay but needs to be taken care of, or a child at home. It says, "Hey, you need to take care of them."
That's exactly right. And that's the incapacitation at death. And that's why a seasoned attorney like yourself can really step in and make things easier. You don't want to immediately transfer all your assets to somebody in the event of incapacitation or death, because then it's theirs. You instead might want to set up a trust that they draw from while they are the guardian of the individual. And at the end of that, that trust then reverts over to the minor child when they become of age, something like that.
Right.
And that's why I say that when you have minor children, when you have a complicated estate, when you have an ex-wife, when you have multiple children, when you have asset classes that get kind of confusing, do it yourself. Well, it is possible. It can open you up for a lot of things that you haven't thought about, that the experience of a professional can really help you out with.
Mhm.
And that's the reality of the situation. You can do it yourself, but
Mhm.
by doing it yourself, you can also mess things up yourself by accident.
Right. So you mentioned before revocable living trust,
Mhm.
uh, and that could you tell me a little bit more as far as what it is, who should have one, and does it replace a will?
Okay. It does not replace a will. So the will is the foundational document. And if you are going to do something with estate planning, step one of the documents you get should be a will.
Mhm.
A revocable living trust is a legal process that transfers assets into a specific legal entity, the trust itself, from you, the grantor, and the grantor can be multiple people, that is available for you if you want to change how those assets are put to work. So the reason why we're saying revocable is because there's also different types of trust that are irrevocable. You cannot change once it is funded. Now, if you can alter it, if you can amend the trust, if you can revoke the trust at any time during your lifetime, it gives you a bit of flexibility to adjust as your situation changes down the road. So that's a
Right.
benefit of it. So effectively, you're saying, I have my will, that this is what I want to have happen to my assets when I pass away. And the trust then is that corollary to it where I'm going to put up a shield so nobody in the public can see what I want to have happen with this money, except the people that I am saying should have access. Those are the individuals that get access to it, who you designate. And there's other benefits that were mentioned quickly earlier that also follow. So the first one is that you get to avoid probate with those assets. So if you have a family heirloom that is very special to you, it's XYZ, whatever it is, but you don't want people to know about it, you put that into a trust and then you have the transfer designation in the trust, and then nobody public is going to find out what happened to that item or that item even exists. If you designate that in a will, that will is going to be filed. Somebody will likely find that will and read it and go, oh, well, Steve had a wonderful car collection. I had no idea knew that existed. Well, you might not have wanted people to know about your car collection. So that's
Mhm.
the first thing. Avoids probate, gives you some sense of security and privacy. The second thing is that, well, the first one is that it avoids probate. You don't have to go through the process. The second one is that it avoids privacy, which we just spoke about. And the third thing is that you get to continue that control of that trust over time as it changes. And you can make modifications, which I cannot stress more is very important. If you're interested in learning about revocable trust, living trusts, sunset trusts, everything down that roadmap, we have an introduction to wills and trusts on the website that's for free. You can go in and read about
Mhm.
it there. But trusts are very complimentary. Do not set those up on your own. I implore you, get somebody who's experienced to help you with that.
Right. And a couple things to bear in mind. I mean, yes, it doesn't go through probate because it's in the trust, but you can't avoid the tax man.
Mm-hmm.
There are still, while it's in existence, you need to file a tax return for that trust. It's under your social security number, but if there's any income being derived from the trust or things like that, you need to put that in there. Uh,
Mm-hmm.
and also, if that trust disperses, depending upon what the taxes are, I mean, and um, the value of the estate, whether there are going to be federal estate tax issues, uh, or state state tax issues, whether estate or inheritance taxes, depending on who the beneficiaries of the trust are. That trustee is still going to need to pay taxes as well. You can't avoid that,
Yep,
right?
that's correct. Like a revocable living trust does not offer tax advantages during the grantor's lifetime.
Right.
The estate tax benefits typically aren't realized until the trust becomes irrevocable upon the grantor's death. That's if
Hmm.
and when you pass away. And you have to keep in mind that you may have state taxes as well. So in 2022, 2 years ago, 12 states in the District of Columbia imposed estate taxes, and 6 of them imposed state inheritance taxes as well. Maryland, where I live, they actually impose both an estate tax and a state inheritance tax, so that's fun. But the revocable trust, you have to understand this is not necessarily a tax benefit avoidance mechanism. It's a privacy control and probate avoidance mechanism that's
Hmm.
flexible and can offer you incapacity planning advantages as well. So
Hmm.
in the event that something were to happen to you, I want this money to only go to this specific purpose.
Hmm.
Yeah.
Now we've laid out some of the advantages of it. You avoid probate. It keeps things private, things like that. But there are people that have a pretty straightforward estate. They
Mhm.
may not need something as involved as a revocable living trust. Uh, One advantage of having one, I have a client that I just prepared a trust for where she has real estate in New Jersey, North Carolina, and Florida. And she's putting all of those into the trust.
Mhm.
Well, if she didn't have that trust and she died, that will would have to be probated in New Jersey, North
Mhm.
Carolina, and Florida
Yep.
to dispose of that real estate. So
Yeah.
if you have these assets that exist specifically in other jurisdictions, it can dramatically increase the cost and time involved in administering the estate.
Mhm.
Are there any other specific advantages or uh, red flags, as it were, that people should look for to see maybe I should
Yeah.
look into a revocable trust.
Yeah, I think one thing that's important to keep in mind is that even if you do put your assets, like the houses that you just mentioned or the property, real property, into a trust, you still have to take all the proper steps to have it recorded as required in the local jurisdiction. So a lot
Right.
of people go, oh, well, I've got the revocable trust, I'm putting my house in it, but they forget to actually file
A
that final
deed.
of of the deed. So now you've got a revocable trust that isn't actually funded and transferred and fulfilled properly. So
Right.
that's a big red flag. It makes things a lot easier and saves time later on, which is the benefit, but you still have to do the work.
Right. And that's
Yeah.
you point out another reason why it's important to have a will as well as a trust, because what if you forget to put something into the trust?
Yeah.
And you want to make sure you have a will with a pour over provision that says everything that I have that isn't in the trust goes into the trust. So you cover your bases that way.
You took the words right out of my mouth. I was going to say that these documents, they don't stand alone. They
Right.
complement and they build upon each other. So the pour over will is unbelievably important that you can avoid everything from probate if you want effectively by saying it immediately upon my desk goes into this specific trust.
Mhm.
It's a complicated process, but that's what makes it fun.
Are there any other advantages that you can think of where, like I said, flags that say, "Hey, maybe I ought to have a," besides the real estate issue and everything, that a trust would be better choice?
I think those are the primary ones. Anything else gets really complicated and in the weeds. I think the most important thing is that if you do start going down that trust rabbit hole, because there are a lot of them that are out there for you, that you take the time to really understand what your estate is and what the goals are and your objectives that you're trying to achieve.
Mhm.
Because people can upsell you, you can believe that this is the best way to do it, but as the saying goes, there's a lot of different ways to skin that cat.
Yeah, well, one other advantage, depending upon, I mean, you need to consider your heirs and who's getting the stuff and everything else. One fear that people have is that they die and the inheritance goes to a child, that money might get lost in a
Mm.
divorce, or maybe they're not very good with money and could blow through it, or end up filing bankruptcy, or being have it attached by creditors.
Mhm.
So a living trust can provide asset protection
Mhm.
for those heirs. Now that it becomes irrevocable upon the death of the grantor. So now you've got this irrevocable trust that has these assets. And if that trust document says, creditors can't get it, bankruptcy trustees can't get it, and as long as there's proper instructions, the proper trustee, all of that, which is going down into the weeds, but
Yeah,
you can protect that legacy to maybe the spendthrift child or the child that's not a very good marriage, and you're worried, and you can have that protection as well.
that's right. And that's really that rabbit hole that we're talking about. Is it
Mhm.
revocable? Is it irrevocable? Do you want to have a spendthrift trust? Is it testamentary? Is it a special needs trust for people that need that?
Right.
Asset protection. Are you using this really just to shield assets from Medicare, Medicaid? So your rates are a little bit lower in some ways. Is it generational skipping trust? So you have familial wealth over time. The bypass trust, which is also known as a credit shelter trust. There's so many different variations of this, and they can all accomplish different goals. And then when you start stacking them together, now you get your layer cake. It can have a very different outcome. But that's an episode, I think, for a much longer and more detailed conversation.
Right. Moving on to, we talked about this a little bit before, as far as the kind of discussions that people should
Yeah.
have with their families regarding their estate plan. You got to make sure they see it coming, right?
Yep.
Have some talks.
Yeah. The the first thing that I think you need to do is just start having the conversation. And
Mhm.
that's the most difficult step. Whether you are a child that's speaking to your parents, whether you are a parent speaking to your child, or someone that's speaking to a spouse or a relative, speaking about the end of your life or the end of their life can be very complicated. This is a plug for Buried in the Work. We created a quiz that you can take. It's 2.5 minutes long. It's free. That'll tell you on a scale of 1 to 10 how organized an estate plan is for you to step in, whether it's yours or someone else's. So you can take it for yourself or you can take it for you as a child or a parent. And with that quiz result, you can very easily go to that individual you want to talk to and say, I just took this quiz. I'm concerned about these results. Let's have a chat. And then you can start talking about it. So that's first thing. Get the ammunition that you need to be able to have the conversation. We also made a game. One is called One More Story. So that's just to gather memories about someone. So tell me one more story about when you were a kid. That's just a fun thing. But the other game, which is directly related to this, is Nothing Left Unsaid. And it's 126 prompts that literally rapid fire. It's effectively the conversation that we just had. Do you have a trust? Do you have a will? Do you have this? Do you have that? What do you think about end of life care? Do you have that? And with those, it'll help you go through and get a good understanding of where you are, and then you can get your action items. The trick is you cannot or should not wait to have these conversations until the last minute, because that opens you up not only to rushing things and making mistakes, but also to claims against it that this was done under coercion or without sound mind. And that's a whole problem in itself. But start early, have the conversation, get things now, and it just makes things so much easier for everybody else down the road.
Well, great. A lot of things for our listeners to think about as far as an estate planning plan is concerned. And you've talked about these quizzes and books and notebooks and resources that you have. If a listener is interested in getting more information, how can they get in touch with you?
It's pretty easy. Go to buriedinwork.com. It's a little punny, but it gets the job done. So buriedinwork.com, free resources for those that are do-it-yourselfers, paid resources for people that need a guided approach, or you can call Steve up. He'll help you out with anything you need, as long as you're in New Jersey.
All right. Well, thanks, Adam, for coming on the show and telling us all about the importance of an estate plan. And I'm sure everybody's got a lot to think about. And folks out there, if you're listening and you don't have an estate plan or you put one together several years ago, maybe it's time to talk to an estate planning attorney. If you're in South Jersey, come on and see me, and make sure you have a plan in place so that you're covered in all your eventualities. So thanks for coming on the show, Adam, and thanks for all the great information.
I enjoyed the conversation. Thanks, Steve.